Okay, so this is part 4. Um, we finished the end of the third part talking about the different defenses to criminal liability, and I'm going to go through those in a little bit more detail now. The first one is justifiable use of force. So this has to do with the defense of self-defense. So say you are in your home and someone tries to break in, you kill them. You say, hey, well, I was just defending my dwelling. Say you have an outbuilding or a detached garage or something like that, you could also have defense of that as being the other property. Or you could say that you did it out of self-defense in prevention of a crime. So your book gives a couple of examples of deadly versus non-deadly force. It's really important to kind of know the difference because the law looks at them very differently. So if somebody's breaking into your home and you don't have any reason to suspect that they would have a weapon, which I don't know why you wouldn't, but if you don't have any reason to suspect that they would have a weapon and you shoot them and kill them, then you are going to face, you could face repercussions for doing that because you, they came at you with non-deadly force and you approached them with deadly force. So generally speaking, the way that the book explains it and the way that the law looks at it is people can use the amount of non-deadly force that is reasonably appearing necessary to prevent the imminent use of criminal force. So you can use the amount of non-deadly force that seems necessary to protect yourselves, your dwellings, or other property, or to prevent the commission of a crime. Deadly force can be used in self-defense only when you believe that imminent death or grievous bodily harm will otherwise result. So you can't do that. Some states have expanded the ability to use deadly force, but I don't think I would take that risk if I were you. So it would be good to know what your laws are in the state where you live. Also necessity, so you did something that was a crime in order to prevent something greater from happening. The book example that they give on page 150 is Jake Trevor is a convicted felon, and if you will recall from what happens if you are a convicted felon, he cannot own a firearm. While he and his wife are in a convenience store, a man draws a gun, points it at the register, and demands all the cash. Afraid that the man will start shooting, Trevor grabs the gun and holds it onto it until the police arrives. In this situation, if he is charged with possession of firearm, he can assert the defense of necessity. So it's not that he owns it, he is just keeping it to prevent something worse from happening. Insanity, we've talked about insanity before. In the case of Justin Thurber, and lots of other criminals have pled insanity. I have to argue that I don't think that that should be a defense. I know there's lots of people on both sides, but I have to say that if you're going to do something heinous to another individual or animal for that matter, you are insane. So I don't know, that just doesn't hold water with me. But insanity is really the definition of using it as a defense comes out of that you're not able, like we talked about before, not able to have the state of mind required to have a guilty mind. So you may have the guilty act, but you can't internalize the consequences of your actions. So it's not like you get off scot-free if you prove that you were insane, because you go to a mental institution if you do. So that's kind of not good. The example that they give is about James Holmes. And if you remember, I don't like to remember criminals' names, but he was the one that shot the people in the movie theater for The Dark Knight Rises. He opened fire with an automatic weapon in a crowded Colorado movie theater during the screening of The Dark Knight Rises, killing 12 people and injuring more than 50. Holmes had been a graduate student before he suffered from mental health problems. Before the incident, he had no criminal history. His attorneys have asserted the defense of insanity to try to avoid a possible death penalty. If the defense is successful, Holmes will be confined to a mental institution rather than a prison. There's also what's called the Moral Penal Code, and that is what's called it defines kind of the boundaries of what insanity would be. let's see. It's fairly short. It says a person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease or defect, he or she lacks substantial capacity either to appreciate the wrongfulness of his or her conduct or to conform his or her conduct to the requirements of the law. There's also the next one, which is the McNaughton test. A person's not responsible if he or she didn't know the nature and quality of the act or didn't know that it was wrong. So it's 4 different states have abolished that one. So there's also what's called the irresistible impulse test. This is, again, super loose for me, very uncomfortable. The irresistible impulse test, where you know the act is wrong, but you can't not do it. So I really feel like it's all of those are really frustrating to me. Mistake. So this quote I liked: "Ignorance of the law is no excuse," but actually it might be. So there are a couple of different ways. A mistake of fact as opposed to a mistake of law can excuse criminal responsibility if it negates the mental state necessary to commit the crime. So let me give you the example which will make that clear. Oliver Wheaton mistakenly walks off with Julie Tyson's briefcase. If Wheaton genuinely thought the case was his, there is no theft. Theft requires knowledge that the property belongs to someone else. If Wheaton's act causes Tyson to incur damages, however, she may sue him in a civil action for trespass to personal property or conversion. Conversion is basically where you convert someone else's property to your own. Stealing is another thing to call it. Duress is kind of best depicted in the picture that I have on this slide, where somebody acts in a way that's not consistent with what you expect of them, but because they were threatened somehow. It also removes the mental state necessary to commit a crime as part of the requirement. In order to they cannot be used as a defense against murder. So if you kill somebody, you can't say, well, someone told me to. That's not going to hold water. Generally, to successfully assert duress as a defense, the defendant must reasonably have believed that he or she was in immediate danger, and the jury or judge must conclude the defendant's belief was reasonable. So it's a little hard to prove, but all of these kind of are. Entrapment is another one, where I set you up as a law enforcement or some kind of agent. I set you up to commit a crime. I kind of entice you. I make it really obvious that no one's going to be watching if you would like to take this. I encourage you in some way to commit a crime. In order to be entrapment, to constitute entrapment, suggestion and inducement must actually occur. The defense is not intended to prevent law enforcement agents from setting a trap for an unwary criminal, so they can sit on the side of the road and wait for you to speed by. That's totally legal. However, the purpose is to prevent them from pushing the individual into a criminal act. So if I called you and said, oh my gosh, there's an emergency, you better hurry, and then I sat and pulled you over, that's entrapment. The crucial issue is whether the person who committed the crime was predisposed to commit the illegal act or did so only because the agent induced it. There's also a statute of limitations that can bail you out if you need defense against a crime. So the state has to remember the state is the one that brings charges in criminal cases. The state has to start the prosecution process within a certain number of years. Murder is the one of the big exceptions to that. So if it's murder, the state there's no statute of limitations for that. They can also toll the time, which is where they suspend it. If the defendant is a minor or not in the jurisdiction, so say, hey, I'm just going to hang out in the Bahamas until this all blows over, that doesn't work, because what the state will do is say, hey, we're just going to put pause on this, and then when you come back, we're going to hit play, and the time will continue to have lapsed at that point. So when the defendant reaches the age of majority, so 18 or 21, or returns to the jurisdiction, the statutory time period begins to run again. Okay, immunity is another one. The Fifth Amendment, if you recall, you just have to think about any TV show or Netflix or whatever where they say, I plead the Fifth. And the Fifth Amendment has to do with self-incrimination. So if I would be telling on myself by by basically confessing to something, I don't have to do that. If the state wants information from somebody that is accused of something, they can grant immunity from prosecution, or they can plea and say, hey, if you will agree to give us this information, we will charge you with a second degree instead of a first degree, or a misdemeanor instead of a felony, or whatever. Again, those are used in plea bargains. Trying to get to the next slide. Okay, so criminal procedures, we aren't going to go through all of these in the videos. You're welcome to read through them, but these are some of the constitutional safeguards for people that that find themselves on the wrong side of the law. So these can help protect you. These are laws that exist as part of the Constitution. Fourth Amendment protections are separate from all of these. Protects the right of the people to be secure in their persons, houses, papers, and effects. Requires a search warrant be issued. So the best is this example that's in your book. Antoine Jones opened and operated a nightclub. Police suspected that he was also trafficking narcotics. As part of their investigation, they obtained a warrant to attach a GPS device to his wife's car. Although the warrant specified that the GPS device had to be attached within 10 days, officers did not attach it until 11 days later. Law enforcement then tracked the vehicle's movement for a month, eventually arresting him for possession and intent to distribute cocaine. Jones was convicted. He appealed, arguing that the police did not have a warrant for the tracking. The United States Supreme Court held that the attachment of a GPS tracking device constitutes a Fourth Amendment search. The court did not rule on whether or not the case was unreasonable and required a warrant, and allowed his conviction to stand. That fact that they didn't attach it until the 11th day might be a procedural violation that he might be able to get off on. So I don't think it's going to serve him forever, but it might be helpful. For a warrant, I can't just say, hey, I don't like this person, put a warrant on them, or a search warrant. I can't do that. It can't be a blanket, or if I suspect they're doing something, I can't just blanket search warrant everywhere that they may be ever. I have to convince a judge that there is probable cause to believe the search will reveal a specific illegality. I can't just say, hey, I have a bad feeling. I have to say, yes, this person is, I think, trafficking drugs, or I think this person is running a fraud scheme from his home computer, or whatever. But I have to be very specific. And the Fourth Amendment to the Constitution requires that those warrants be very specific in nature. They can't just be, like I said, a blanket warrant. The exclusionary rule, we'll go just a little bit further here. Any evidence obtained in violation of the constitutional rights in the Fourth, Fifth, and Sixth Amendment is not admissible at trial. It's called fruit of the poisonous tree. If you see in the picture over here, that's where that phrase came from, which was from a case. Also, the Marcus versus Gray case that I mentioned that came from the Kansas Supreme Court, the case that was heard on campus. Marcus believed that he was pulled over because of a racial profiling situation, which would have been a violation of his constitutional rights. If that is the case, the information that they got from him after pulling him over for that stop that was not constitutional to begin with would not be admissible. We'll pick up with the Miranda rule for the last video.